DS, father of DJS and C.H.S. children v. Department of Children and Families. We're here for a sanctions hearing addressed to Attorney Michael Tupper. Let me introduce the panel. I'm Judge Lambert, as Doug was able to remember after reading things. I'm Judge Lambert, and I'll be presiding. To my right and to your left, Mr. Tupper, is Judge Joe Boatwright, and to my left and to your right is Judge Paige Kilbane. The reason we're here today is there's a show cause order. Working backwards a little bit, there's the August 1, 2025 order of this court directed you to appear for a hearing on September 16. We did not discharge an earlier order to show cause based upon your prior response. That September 16 meeting had to be rescheduled due to some medical issues that were involved, and so we rescheduled it here to today at 11 o'clock. So just some preliminary matters. I mean, we're obviously not an evidentiary court, so we're not going to swear you in, but your name is Michael Tupper, correct?
That's correct, Your Honor.
And what is your bar number, sir?
It's 0734691.
0734691?
That's correct.
Okay. I would say that we're being live streamed, but for some reason our live stream is not working today. Apparently it'll be up tomorrow, but it is being recorded, so there is a record of this, as well as we're being obviously recorded audio tape. But in any event, even though I'm not going to swear you in, I'm going to assume that you as an officer of the court are going to give me truthful responses and give truthful responses to any members of the court who may ask you questions.
Yes, Your Honor.
Okay, very well. Let me ask you just some preliminary matters. How long have you been a member of the Florida Bar?
Over 20 years.
When did you get admitted? What year?
May of 2023.
May 2023 is 2 years ago.
I'm sorry, May of 2003.
May of 2003. So you've been a member of the bar since May of 2003, and your law office is in Jacksonville, Florida?
That's correct.
Okay, and what is the name of your law office?
It's Tupper Law.
Tupper Law? Okay, how many lawyers are in that firm?
Just one. I'm a sole practitioner.
You're a sole practitioner? Yes. How many people work for you at your law office?
I have 2 employees. My spouse works for me on occasion.
Okay, and the employees are, what do they do?
I have a paralegal, and a legal assistant.
Okay. Have you ever had any prior bar discipline?
No.
What would you say, if any, is your area of specialty?
Juvenile dependency and termination of parental rights. I also practice in the area of family law.
Okay. Is it primarily trial work, or do you? I mean, I know you're here on an appeal, and we're talking about your activity.
I do primarily trial work, but I have appeared in a great number of appeals.
When did you start doing? Well, let me rephrase. Is any of the appeal work you do solely in the juvenile dependency TPR area?
I do the rare family law or domestic violence appeal.
Okay. Have you appeared before any other district court of appeal other than the 5th?
In terms of
or briefing first.
Oh, the first as well.
The first before
because of the realignment.
Because of the realignment. So, have you appeared in any oral arguments?
I have not.
All right. Roughly how many cases do you think you've filed briefs in on appeal?
Ooh, that would be difficult to calculate.
I'm not going to go back and see. If you told me 62 and I say, I know how it's only 61, I got you. I'm not doing that. I just kind of want a general idea about your experience in appellate world. You said primarily what you do is trial work in the juvenile dependency.
I would say in the range of 30 to 40. A lot of it was while I was with the Department of Children and Families.
How long were you with the DCF?
9.5 years.
Was that right out of, is that when you, starting in 2003 when you became an attorney, or sometime thereafter?
Even prior to that, I started as a legal assistant.
Okay, so before you became a licensed member of the bar, you were working for the DCF, and then once you became a member of the bar, you continued on working for the DCF?
That's correct.
Upon leaving, did you continuously work for the DCF?
I'm sorry, I don't
Did
understand.
you work for the DCF and then move on to private practice or do something else, or was that?
I moved on to private practice. I opened Tupper Law in February of 2013, and I continued to be involved in juvenile dependency cases and TPR cases
Okay.
at that time as a court-appointed attorney. And
Were you the trial attorney in this case below?
I was the trial attorney, yes, sir.
In DS's case, father's case?
That's correct.
Okay. Were you retained to do the appeal? Were you court-appointed to do?
I was court-appointed to do the appeal.
You ever have any other issues with similar type of issues that you're here in front of us today on?
The court noted in one of the orders that there was a case that was dismissed for failure to prosecute or to file a brief. I believe in all those other cases, the appeals were reinstated.
So how many prior cases would you think?
I can think of one in a juvenile dependency case and one in a domestic violence injunction case where I privately represented the appellant.
So 2 prior cases?
Yes.
Are you board certified?
I'm not.
Well, there was actually, at the 5th DC, again, the realignment took place on January 1 of 2023. You had an early, and we're not here per se about these earlier cases, but there was one case, 2023-3758, in which you represented the father, and I see that we had a May 30, 2024 order in that case directing you to show cause why you had not responded to at least 3 orders in that case. That case, I believe, ended up, you filed a response indicating that you were implementing additional calendaring procedures to prevent the oversight. At that point, the panel, Judge Boatwright was on that panel just for purposes of transparency. So you were just, that order to show cause was discharged in that case. That panel accepted that. And then earlier this year in 25-0477, there was again another order to show cause, July 9, why you should not be sanctioned for failing to timely prosecute the appeal. The appeal was dismissed. You know, in those cases and in this case, you know, your substantive response eventually, I believe, was, and I'll paraphrase, was that there's no merit to the appeal, so not much I can say on behalf of the appellant. The concerns that I have and that perhaps the panel shares with me is there's orders that are entered in these cases telling you to do things.
Yes, Your Honor.
And there's a pattern culminating in this case that we enter orders saying, you know, we've told you, not asked you, we've told you to do certain things. Respond to us.
Yes, sir.
And you don't. And, you know, going back to 2023, you know, you said, well, I'm implementing a new calendaring procedure here. In this case, you belatedly, i.e. 3 days ago, filed a response, including, that had paragraph 9 of the response that says, well, my wife underwent surgery in February. I had to take care of her, and then in April, you had surgery. And
Had medical issues, not surgery.
okay, thank you for correcting me, sir. I appreciate that. I don't mean to misstate the record. This appeal, the notice of appeal in this case, was after those things. It was April 29. And you're familiar, because you do this work, with a juvenile expedite order, saying, we need to get these things because there's a time frame, there's an expedited time frame on these cases. And starting with that juvenile expedite order of April 29, which they go out on the day we received the notice of appeal, you were told to do things which didn't take place. And then there's repeated orders in this case saying, show cause, why are you not doing anything? Why are you not responding to these things? And you didn't, we had this case set for hearing in September. There wasn't a response. I mean, your response to the order to show cause, we didn't find it as reason explaining to us, well, why don't you respond to our orders? You may tell us that the case has no merit, but you're not telling us why you're ignoring our orders. And as we're talking about it, you're not being, the sanction hearing is not directed to the earlier cases that I have referenced, but the concern that we have and why we're talking today is, we're all human, we all have moments here. This seems that the times we have you in these appeals, and they're critical because they're dealing with parents, parental rights being terminated, we're not getting through to you to respond to our orders. I mean, and it becomes more problematic to, if you're a pro se litigant, I mean, we don't excuse them, but we understand that. But when we're dealing with an attorney who you admittedly tell us you practice in this area, and you're familiar with this, and you have practiced in this area for 22 years now.
Yes, Your Honor.
Can you give us any explanation why it is that you are not responding to court orders that we send to you about do something? In fact, some of these orders even tell you, if you just send us a notice, tell us things, that will discharge the order to show cause, and it gets past that. This case has been dismissed. The mandate's been issued. I know there's a motion for reinstatement, and I probably don't even have the authority to rule on the motion to reinstate since the mandate's been issued. But I mean, where is there any ability for us to believe that you should continue to practice in front of us because you seem to regularly ignore our orders? I mean, I'm not trying to be ugly about anything, but I'm looking at the record. I've never met you or know of you before. It's just as puzzling to me that orders have to be kept being sent to you to get you to do something. And, it's only when it becomes concerning, apparently. Anecdotally, I understand. When I was a trial judge and we used to mail things, I was the one that mailed my orders to the attorneys. And I would have attorneys ignore my order until we were going to dismiss things with prejudice. Then for some reason, the attorneys actually got that mail from me. Well, the other mail they didn't get from me in the case, and they ignored. And so I guess this is your chance to explain or to mitigate any of the concerns that we have about whether to impose sanctions against you. So feel free.
Yes, sir. I do understand the court's frustration, and I'm very sensitive to these cases have an impact not just on the litigants, the parents, but also on the children. Because ultimately a delay in the prosecution of the appeal would results in the delay of implementing permanency, permanent placement for those children. I did have a very overwhelming period this year, including medical struggles, health struggles that did persist past the point of the initiation in this.
Why wouldn't, I mean, I don't know there'd be any hesitation if you filed something with us saying, I've been appointed to this case, my wife and I are undergoing serious medical issues, I don't believe I can devote the time needed to this case, I'd move to withdraw, please promptly appoint somebody. I think we'd appreciate that, saying, well, things happen in everybody's lives, we all have that happen. Let us know. But I mean, let's say what it is. I mean, this hearing was set in September. You didn't file anything with us and saying, oh, by the way, I had this serious medical condition and my wife had this surgery. You didn't do that. We had to continue the hearing for, again, I said for medical reasons, and then it's only a couple days ago that you give us some explanation of this was what's happening to me externally as to why I didn't, I guess it's your explanation why you didn't respond to court orders.
Right.
I mean, we're not going to investigate that, but I mean, with your history of not responding to earlier orders of a similar vein in similar type cases, you told us in 2023 you improved your calendaring so this won't happen again. That's part of your explanation here, together with the medical issues that you've raised or told us about.
Yes.
I mean, where do we get the comfort level that having you on the case, that we're going to get the briefing or equally significant respond to any orders that we send? Tell us how we have a comfort level with that.
Yes, Your Honor. Just other than to say that there was a significant amount of guilt or shame to not performing up to expectations, and to certify to the court that I will just simply do better and to be responsive to the future orders of the court.
Okay, and I'm not trying to embarrass you. I'm trying to get to the root of the thing and just say, how do we go forward, if at all, with you in these cases? What's the new methodology that you may have implemented so that when there's actually an order sent to you, or when there is an order sent to you or to your office, that somehow that becomes a priority to look at it and respond to it, in some fashion?
Yes, Your Honor. We've been in the process of implementing a case management system. It's a well-known case management system, Clio.
What kind of case management system?
Clio.
I'm sorry.
Clio.
Clio? Okay. And you're in the process of implementing that? Is that what you said?
That's correct.
Okay. And Mr. Tupper, when did that implementation begin?
It's kind of been in stages in terms of implementing it in the trial work. That's been an ongoing, that's been for some time now, in terms of using it to track the incoming orders coming from DCA. I can't be certain when we implemented that practice. But
Okay,
in terms of having like a second level backstops and things on my calendar, that's been a recent process of continuing to detail the implementation of those new court calendaring rules.
Okay. Back in 2023, what things did you do? You represented to this court in 23, 24, and 25 that you had changed those safeguards. Are you telling this court that you've been implementing Clio for 2 years, or is it a different process?
It was a different process, rather than just relying on just a straight calendar. The Clio process is a new process to the office.
Okay. And is there are multiple people or one person who are getting electronic orders from courts in your office?
There are multiple people now.
Okay. And how many cases, whether it's trial court cases, appellate, how many cases, open cases, does your office have approximately? Again, I'm not trying to trick you.
Somewhere in the neighborhood of 80 to 100.
How many appeals do you have pending with us right now? Do you know?
I have 2 others, I believe, that are pending right now.
And do you feel as though you have the ability, if you don't have the bandwidth to handle these cases for whatever reason, whether it's a personal reason or just you're too busy, do you feel as though you have the ability to decline the case?
Do I have the ability to decline the case?
Yes.
Yes, I do.
And do you understand that at some point, if you can't handle that case, that that is in fact your obligation as a member of the bar?
I do.
Okay.
Thank you, Your Honor.
I guess what that puzzles me a bit is when you get orders from us, both in this case and the earlier cases, saying, you haven't filed an initial brief. Tell us why the case should not be dismissed for failing to file an initial brief. And you're also advised in these show cause orders that if you don't tell us about this, you could result in sanctions against you. Those cases get dismissed. I mean, I know you moved to reinstate them, but I mean, the orders go out. It just strikes me that if I'm an attorney and I get an order saying a TPR case is going to be dismissed unless I do something of which I'm obligated to do as the attorney, that doesn't, Clio or any other system aside, writing it down on a piece of paper and saying, hey, I got this in the email today, we got to do something. Just say, well, it'll get it'll get calendared, and that doesn't come to the forefront to the point that all these cases have been dismissed, and there may have been no merit to any of these cases from a reversible error being able to be shown. And I know you filed your Anders type motions. I know they don't call them Anders in this case; it's NACH versus somebody, but that's just disconcerting from an appellate court standpoint to say, in these cases, of all cases, the counsel has said, we're not getting a brief and this case is going to be dismissed. These kids it'll be over for these parents, and again, that may well have been the merits result of the appeal, but they don't get a chance to get there because we dismiss the case, because as with almost every other case, there's certain summary criminal cases, but as in any other case, if the appellant who has the burden of proving reversible error doesn't tell us anything, we don't hunt for reversible error and raise it, that hasn't caused any, your behavior hasn't seemed to change over the years in that, and saying, well, I have a system that's, as you respond to Judge Kilpain, I have this system that's being implemented. Okay, I mean, we've gone through a unique C-track implementation of a tracking cases that some of us have varying views of it. But that being said, at the end of the day, it's your responsibility, whatever your system is, to say, hey, I've got this order, system be damned, I have to do something. This court is telling me to do something. I got to do it.
Absolutely, Your Honor.
I respond. My wife has been ill. I can't do it. I apologize. Could you please substitute somebody else? Which I suspect would be, met with probably approval. I mean, I can't speak for a panel per se, but
Yes,
and
Your
I mean, this is your chance to convince us why we should have a comfort level that this is just a one-off thing, that this isn't going to happen again. I mean, I know you have not been, eventually were not sanctioned in the earlier cases. They accepted your explanations, or they decided just to proceed and not sanction, but I mean.
Yes, Your Honor, I do look forward to, number one, not having any further orders that would require a response under the threat of sanction, and number two, working with diligence and with the urgency that's required, and my apologies, Your Honor, with the urgency that is required in all of these situations. I
mean, if this is just not an area you want to do, if you just don't want to practice in appellate world, that's one thing, and then I guess you would not be you could be taken off the appointment list. I mean, I don't understand the processes that we just start randomly picking people to say, well, you're going to be, this isn't 80 years ago. We don't just say, well, that guy's walking down the street, he's going to be the appellate attorney today for this case. I mean, we don't, that's not the process. I mean, you have to basically ask to be on the, and we're not making you do this, and it sounds like your representation in these appeals are all court-appointed. I mean, if this is just something you don't want to practice in this area and you want to stay in the trial court arena, you know, then you wouldn't have to worry about responding to orders from this court anymore, because you wouldn't be in this court anymore. You know, we're not banning you per se, but we're just saying, you know, it's disconcerting. I mean, because again, this is the third time in 2+ years that this is the first time you're having a sanctions hearing, but you have certainly seen a number of orders to show cause saying you're not responding to orders. I mean, it's not a party invitation. We're ordering you to do something, and basically we're ordering you to respond about things as opposed to anything else, and that seems to be not taken with the seriousness that perhaps it should have been. I.e., because because you keep getting threatened with sanctions because you're not responding.
At this point, it will be taken with all due seriousness, Your Honor, and in terms of, you know, responding, you know, with diligence and with a sense of urgency that these matters require.
So you want to continue in the appellate practice in this arena?
That would be my preference, yes, Your Honor. I do ultimately enjoy the appellate practice. It's something, you know, when I've had, you know, positive outcomes, which are often few and far between in these cases, but when I've had positive outcomes, it's something that I take a great deal of pride in.
Any other questions? No, sir. Okay, last chance. I mean, I'll phrase it that, you know, typically on show cause, I mean, in getting at we all used to be trial judges. Putting our trial judge hats on in the old days in contempt, you always gave the person a contempt hearing the chance to, you know, give the final say in mitigation, anything you want us to further take into consideration before we adjourn and discuss this hearing.
I appreciate the thoughtful consideration that you all have given me in this case an opportunity to introduce myself and for you to get to know a little bit about my practice. I don't have anything further to add at this time.
Okay, counsel, thank you very much. You're excused. Have a good day, sir.
So, I'll be dismissed.
You can go. Yeah.